boldip.com.
J.D. Hoovener. I'm the managing partner and owner of Bold IP. It's my pleasure to be with you here today at this version of Bold Bits. Today we're going to talk about restriction requirements. And before we get to that, I want to do a brief introduction of our law firm, if this is your first time viewing. Bold IP is an agile law firm where we focus on working with inventors and business owners in a business-minded approach. All of our patent attorneys have industry or business experience, and we love working with inventors and those inventions and making sure that they not only receive the patents and the granted right that they get at the end of the train, but that they actually have a plan, a business plan, for monetizing those inventions in the marketplace. So without further ado, I will jump into our discussion about restriction. And so one thing about restriction that you should know is that it is a course regarding patent law. And when an invention is finally submitted to the patent office, all the application work, all the searching is already done. The very first thing that comes up, it doesn't always come up, but it most likely does, is the examiner is going to try to decide, is the application that this inventor submitted, is this construed to one invention, or are there actually more than one invention that the inventor is trying to get by? There's a general premise that the patent office really is only supposed to allow one invention per patent. Okay, it sounds kind of simple, but it is really the very first inquiry that the examiners are up against. And the examiners, though they have a lot to look at, their first notion for this is going to be they look at the MPAP, which is the Manual for Patent Examining Practitioners, and the chapter is 800. And so let's dive in a little bit here, and I'll share with you my screen on this, and we can take a look at chapter 800, which is the restriction requirement. And so when an examiner is trying to make that decision on whether, is this invention, just one, or are there actually more than one inventions here? Because only one is allowed. And so when they make a restriction requirement, they don't always do this. They're saying that there's at least two inventions. And the reason why, they have to explain very thoroughly that there are specific reasons for these more than one inventions. And so there's specific criteria, and you can see here under section 803 that there are two criteria for proper requirements. First one is the inventions must be independent. Okay, so they must actually show and demonstrate under these separate sections that that they're not coextensive, meaning one does not rely on the other, one is not dependent on the other functioning. And the next one is that when the examiners go about doing their search, and they're going to start to develop their plan for making sure there's no prior art, no earlier inventions or publications that are very similar or exactly the same as the inventor submitted. When they begin doing that search, they have to understand that there's lots of different classifications. And so it is really up to the examiner. They've got lots of applications that they're looking at. They've got to make sure they budget their time efficiently. And so if they have to look at multiple classifications to do their searches, they're going to say, whoa. I'm not doing search on multiple classes. These are very separate inventions. The burden to do the search is too great. And so you can see under B, the examiner must show there would be a serious burden if the restriction is not required. Okay, so both of those, the invention must be independent, and there must be a serious burden on the examiner to conduct a thorough search, given the time they have for just this one invention. There's some guidelines that need to be followed, but it's important to understand right up front, what does that mean? And so we'll dive into what does it mean to be independent. Okay, and independent, of course, doesn't mean related. It means unrelated, meaning, and it actually is a very positive thing for the inventor, if you think about it, because if you're thinking about it from a broad perspective on total invention value, the examiner is saying, look, these are actually non-obvious variants of each other. And it's not a bad thing to have more than one invention. The only downside, of course, is that there's going to be additional filings, and you'll have a what started out as one invention. If it does get restricted, part of that claimed invention is going to get separated, and you'll have what's called a parallel track, and you'll actually have two invention applications pending in the USPTO, and they can each have their own separate office actions, and one could get granted before the other. And then at the end, you're going to actually have to maintain both inventions through maintenance fees. And you'll have twice as many maintenance fees if there are two. So that's kind of the downside. The upside to the process is that the examiners are making a definitive point. They make their argument for you that these inventions are not obvious variants of one another. And that's one of the main three characteristics of getting a patent through. It must be novel, non-obvious, and have utility. So the examiner's already done that second one for us in this scenario. If you take a look at the overall process of doing a restriction, and the main point of doing a restriction is to try to make the process more efficient for the examiner. And in doing so, there is one major thing to think about, in that when you respond to the examiner's restriction, you have a choice of either traversing, meaning argue and try to petition to say, no, examiner, you're wrong. These are actually the same invention. It's all part of one species. And that's one path to go down. The interesting thing about it is that the examiners, and the way the process is set up, is you have to elect one species. Let's say the examiner says, no, there are two species, meaning there are two inventions here, and let's say there's 20 claims that were submitted. Claims 1 through 10 are construed to species 1, and the examiner thinks that claims 11 through 20 you're actually claiming that's invention number 2. So you as the inventor and as the attorney advising the inventor need to wisely select which set you would like to move forward with, even if you are arguing that all 1 through 20 are exactly the same. So it's a way to proceed in sort of this reservation for the ability to then take it on appeal later if the examiner does not agree with your arguments. This sort of saves another back and forth step with the USPTO, and the idea, I believe, is to save a little bit of more money and be more efficient. So, as you can see, there's a lot to look at with restriction requirements. The high-level look at this, you've got improper joinder, double patenting, distinctiveness. There's a lot to look at as far as what's distinctive depending on what type of claim there is. There's also linking claims, actions on the merits, time for making a requirement, and as you can see, it goes quite a bit into detail. What I would recommend is if you have filed a patent application, either on your own or with an attorney, and they're not familiar with the restriction process, please do get with an attorney that does know how to handle this and knows how to be in your best interest, help advise you through this very important first hurdle that often comes up at the USPTO. Know that Bold IP will be happy to help you with that, be more than ready to and equipped to help solve that problem for you. Without further ado, we'll end our Bold Bits session, but it's been a pleasure being with you here today, and I thank you for tuning in. I wish you all a great day and have a wonderful week. Go big, go bold.
Go big, go bold at boldip.com.